Hello, today we are discussing about the rights of an accused. The preamble of the Constitution reflects the aspirations of the people of India to secure justice, liberty, and equality to all citizens. A person may become accused when there is a criminal charge against him and he can be put behind the bars to face the consequences. An accused, when brought before the court of any category, does not cease to be a citizen of this country despite the fact that he has been charged treated of an offense. Hence, under the Constitution, Article 5, even an accused does not become non-citizen on the mere fact that he has been arrested, charged treated, or inculcated by the authority. Being a citizen of this free country, the accused is entitled to all those entitlements that any free citizen is entitled, except those curtailment that had been restricted by the virtue of his arrest according to the law of this land. There are various rights of an accused. These rights can be classified into three categories: right of an accused pre-trial, the right of an accused while the trial is ongoing, and the right of an accused after the trial. First of all, we are going to look at some of the important rights of an accused, the pre-trial. First one, right to know about the accusation and charges. An accused person, when arrested by the police, must be told about all the details of the offense and the charges filed against him or her. This right is provided by the CRPC under Section 50 and 75. The second one, right against wrongful arrest. The right of an accused in India is provided only in cases where the warrant is issued. An accused person, when arrested by the police, must be told about all the charges and accusation against the said arrest of the person which has been made. This right is provided by the CRPC 50 and 75. Now the third one, right of privacy and protection against unlawful searches. As per Article 21 of the Constitution of India, no person should be deprived of his or her personal life and liberty except if according to the procedure of law. The police officials cannot violate the privacy of an accused on a mere presumption of an offense. As per right of an accused in India, his or her property cannot be searched by the police without a search warrant. Now, the fourth one, right against self-incrimination. In criminal law, every person who is involved in a criminal proceeding provides a statement that gives light to the fact of all the cases. An accused person also provides this statement, he or she, to answer each and every question raised to him or her by the police officer relating to the ongoing case. But while providing the answers of the question, the accused person has a right to answer those questions which can be incriminate him. This right is known as the right against self-incrimination, which provided under Section 161 Clause 2 of the CRPC and Article 20 Clause 3 of the Constitution of India. Now, coming into the fifth one, right against double jeopardy. A person cannot be prosecuted and punished for the same offense more than once as per Article 20 Clause 2 of the Constitution of India. Now, coming into the next one, the right against ex post facto law. The right of an accused in India also gives a person the authority where he or she cannot be tried for an offense that was earlier a crime and now is not. This means that the retrospective effect of law is not applicable. An act that was not a crime on the day when it was done cannot be considered as an offense. Now, coming into the seventh one, bail as a right of an accused in India. The right of an accused person allows them to file a bail application to be released from the jail custody except if he or she is accused of committing a non-bailable offence. Now, coming into the eighth one, as per section 304 of the CRPC, if an accused is not able to afford a lawyer, he or she must receive the required legal aid at the expense of the state. Now, the ninth one, right to a free and expeditious trial. Every person alleged to be an accused has a right to be heard without bias. This is a natural right inherent in every person. No prejudice should hamper the right to justice of an accused. This right is implied right protected by the virtue of Article 21 of the Constitution of India. Now we are going to look at the right of an accused during the trial. The first one, the right to be present during the trial. Section 273 of the Court provides that all evidence and statements must be recorded in the presence of the accused or his criminal lawyer, unless it is expressly provided that the accused should not be present at the time of such presentation, or the accused is absent intentionally. At the two situations, the trial can be proceeded without the accused being present in person in the court. Now coming into the second one, the right to get the copies of documents. The accused has the right to receive all the copy of the documents filed by the prosecutor in relation to the case, in order to complete knowledge regarding the ongoing process in the trial. This right is provided under section 76 of Indian Evidence Act 1872. Now coming into the third right to be considered innocent till proven guilty. This is also called the presumption of innocence in the UN Declaration of Human Rights. It is considered as the fundamental right of every accused. Now coming into the fourth one, right to cross-examination. It is the right of an accused in criminal cases to be cross-examined by the prosecutor to prove their innocence. Now coming into the right of an accused post-trial. The right of an accused after completion of a trial depends on the outcome of the proceedings, hence the judgment. According to the verdict of the court of the trial, the right of an accused changes. If the accused is convicted by the court of a trial, the major right which lies with the accused is the right to appeal to the higher jurisdiction. That means the accused can file an appeal against the ordinance or judgment passed by the lower court. If the accused is acquitted of the charge he or she was alleged accused of, and the person accused has a right to get the copies of the judgment of the acquittal passed by the court of trial. In D.K. Basu vs. State of West Bengal, the Supreme Court in this case issued some guidelines which were required to be mandatorily followed in the case of arrest or detention, which include the arresting authority should bear accurate, visible and clear identification along with their name tags with their designation. The memo be signed by the arrestee and the family member. The family or the friend must be told about the arrest of an accused. The arrestee may be permitted to meet his lawyer during the interrogation, throughout the interrogation, and many other. Custodial death and illegal arrest is a major problem in India. It infringes the Article 21 of the Constitution of India and also the basic human rights which is available under the Universal Declaration of Human Rights. The guidelines is issued by the Supreme Court in D.K. Basu vs. State of West Bengal is not properly implemented. The court of law and the purpose of law is justice. It has been universally acceptable as the human value that a person accused of any offense should not be punished unless he has been given a fair trial and his guilt has been proved in such trial.